Millbrook Ridge, Georgia. A quiet woman. One old deed. The HOA broke ground without asking. Neighbors cheered as bulldozers rolled in. She said nothing, because she already knew something they didn't. The HOA president started losing sleep. By the end, the whole town would remember her name. My name is Grace Calloway, and I never wanted trouble. I work as a real estate paralegal in Atlanta. 40 minutes from the 40 acres my grandfather Walter left me 2 years ago. I kept it quiet, overgrown, and mine. I liked it that way. I have a daughter, Emma, 7 years old, and a job that keeps our lights on. The land was supposed to be our someday. A house, a garden, place with no landlord. I never imagined an entire subdivision would decide it belonged to them first. Ashford Meadows sits just north of my property. A gated community of beige houses and manicured cul-de-sacs, built 8 years ago on land that used to be pine forest. I'd waved at my new neighbors a few times. I didn't know their HOA president yet. That would change soon enough. Her name was Regina Voss. Everyone in Ashford Meadows either loved her or feared her, sometimes both in the same sentence. She ran the HOA board like a small kingdom, and she had plans for expansion that went far beyond flower bed regulations. Regina wanted a commercial district, retail shops, a medical plaza, offices, something to raise property values and, more importantly, her own profile in the county. She'd been quietly shopping the idea to developers for over a year, looking for land close enough to matter. Ideally land that would cost the association almost nothing to acquire, so the eventual profits would look larger on paper than they honestly were. My 40 acres bordered the subdivision's northern edge, mostly untouched, mostly forgotten by everyone except me and the deer that grazed there. To Regina, it looked like empty space waiting for a purpose. She had no idea it had an owner who checked in every weekend. The trouble started with an old plat map from 1979, filed when the original developer carved out Ashford Meadows from a larger tract. Somewhere along the way, a surveyor's note referred to adjoining common reserve, language nobody had updated in decades, language that would soon mean far more to Regina than it ever should have. Regina found that note in a box of dusty HOA records during a spring cleanup of the clubhouse office. She read Common Reserve and her eyes lit up. She didn't call the county. She called her husband instead. Dale Voss worked at a regional title company, the kind that processed dozens of closings a week without blinking. Regina asked him one question. Could that language mean the land technically belonged to the HOA? Dale, eager to please his wife, said maybe, and that was enough for her. Within a month, Regina had convinced the HOA board that my grandfather's 40 acres were an unclaimed reserve parcel, never properly deeded out after the original 1979 subdivision. She proposed a plan, build a commercial center there, generating rental income for every homeowner in Ashford Meadows, presenting rough sketches and rosy projected numbers before anyone had even suggested hiring an attorney to confirm the underlying premise was true. She brought in a developer named Todd Bryant, smooth-talking and hungry for a project after 2 deals fell through that year. Todd didn't ask hard questions either. When a client says the land is already theirs, a builder eager for work rarely digs deeper than he has to, and Regina's confidence made digging feel entirely unnecessary anyway. The HOA board voted 5-2 in favor of the commercial project. Only Marcus Webb, the treasurer, hesitated, asking whether anyone had actually pulled the county deed records. Regina brushed him off, saying she'd handled the legal side already. She hadn't handled anything. Permits moved fast, faster than they should have. Regina knew a clerk at the county planning office, an old friend from her sorority days, who processed the paperwork without flagging the missing chain of title. Small towns run on favors, and favors don't always ask for proof, especially when the person asking sounds as certain as Regina always did. I first noticed the survey stakes on a Saturday morning in April. Little orange flags marching across my grandfather's back field like an invasion. I walked the property line twice, counting stakes, feeling my stomach tighten with a dread I couldn't yet name. I called the number stapled to one of the flags. A cheerful voice answered, "Bryant Development Group, project coordinator speaking." I asked what project. She said a retail and office complex, cleared for construction by the Ashford Meadows Homeowners Association. My hands went cold. I drove straight to the HOA clubhouse that afternoon, deed folder in hand, ready for a 2-minute conversation that would clear everything up. I found Regina Voss behind a desk covered in blueprints, looking like a woman already celebrating a victory she hadn't earned, sipping coffee from a mug that read, HOA President, because someone has to. I introduced myself and explained, calmly, that the surveyed land was my property, inherited from my grandfather, deeded to me 2 years earlier. Regina barely looked up. "That parcel's HOA common reserve," she said. "Your paperwork must be outdated." "Sweetheart," I told her I had the recorded deed right there in my folder. She waved a hand like swatting a fly. "Recorded deeds get corrected all the time," she said. "I'd hate for you to embarrass yourself telling people you own HOA land." I left before I said something I'd regret. That night I couldn't sleep. My grandfather's original 1979 deed, the surveyor's plat, the county tax records showing my name on the parcel for 2 straight years. Everything matched. Mine. Clearly, cleanly, on paper. I called the county recorder's office first thing Monday. The clerk confirmed what I already knew. Parcel 114B was recorded under Walter Calloway, then transferred to Grace Calloway upon his death. Filed and stamped. No ambiguity. I asked her to email me the confirmation immediately. Armed with that email, I called Regina again, this time recording the call, a habit from years of handling contentious closings at work. I read her the recorder's exact language. There was a pause on the line. The first crack in her voice I'd hear. "There's clearly been a clerical mix-up somewhere," Regina said, recovering fast. "I'll have our attorney look into it. In the meantime, please don't interfere with active construction. That's a liability issue for everyone involved." She hung up before I could answer. I should have gone straight to a lawyer that day. Instead, foolishly, I gave her the benefit of the doubt, thinking a homeowners association president wouldn't dare break ground on private land without triple-checking the title first. I underestimated exactly how far Regina was willing to go. 2 weeks later, heavy equipment arrived. Not survey trucks this time, excavators, dump trucks, a construction trailer parked right at the edge of my grandfather's old orchard. They didn't ask permission. They didn't wait for lawyers. Regina had decided the land was hers, and she moved like it. I stood at the property line in work boots, watching a bulldozer knock down a row of pecan trees my grandfather planted the year I was born. Something in my chest cracked. I called the sheriff's non-emergency line, voice shaking, and reported active trespass and property destruction. 2 deputies arrived within the hour, more confused than alarmed. The site foreman showed them a permit packet stamped by the county, listing Ashford Meadows HOA as the property owner of record. The deputies looked at my printed deed, looked at the permits, and shrugged helplessly, clearly unwilling to referee a dispute between paperwork that seemed, on its surface, to contradict itself. "Ma'am, this looks like a civil dispute, not a criminal matter," one deputy told me gently. "You'll need to sort ownership out in court. We can't stop permitted construction based on a private disagreement." I watched them drive away as another tree came down behind me. I called an attorney that same afternoon, a friend of a friend named Priya Anand who specialized in real estate litigation. She listened to the whole story, then said one sentence that steadied me. "If your deed is clean, this is the kind of case that ends careers." Priya filed for an emergency injunction the next morning, citing clear title and ongoing irreparable harm to timber and land. It would take days to get before a judge. She warned me. Construction moved fast, courts moved slow. Every day mattered, and every day the HOA kept building. Meanwhile, word spread through Ashford Meadows that some woman was trying to block the community's exciting new retail project. Regina made sure of that, posting updates in the neighborhood app, framing me as an outsider trying to sabotage the homeowner's shared investment for no good reason. Neighbors I'd never met left comments calling me difficult, entitled, a NIMBY standing in the way of progress. Nobody asked to see my deed. Nobody wondered why a subdivision 15 years old suddenly discovered shared land it never mentioned before. Regina's story was simply easier to believe. Todd Bryant, the developer, doubled his crew size that week, working weekends, pouring foundation footings faster than usual. Priya warned me this was a common tactic. Build fast enough, and courts sometimes hesitate to order demolition of a half-finished project. Worried about wasted value, I documented everything obsessively now. Photos, timestamps, drone footage a friend flew over the site, copies of every permit I could pull. Priya said we were building a paper trail no judge could ignore. I hoped she was right, because Regina certainly wasn't slowing down. At the emergency hearing, Regina's attorney argued the 1979 plat language was ambiguous enough to justify a good faith belief in HOA ownership. The judge wasn't fully convinced, but wasn't fully persuaded to halt construction either, and issued only a partial restraining order limiting further land clearing. A compromise that satisfied absolutely no one sitting in that courtroom that morning. It was a small win, but not the win I needed. Construction on already cleared land could continue. 22 building pads had already been staked and partially poured. Regina's team simply worked around the restrained section, grinning through every camera that caught their crews still moving. That night, Marcus Webb, the HOA treasurer who'd voted against the project, called me out of nowhere. "You should know something," he said quietly. Regina never actually got a title opinion before this started. She told the board she had. I don't think she ever did. Marcus explained he'd asked for the title report twice at board meetings and been told it was in progress both times. He'd started keeping his own notes after that, uneasy about how fast everything moved without paperwork. He wasn't ready to go public yet, But he wanted me warned. I asked Priya what that meant legally. She said if Regina proceeded without any title verification, it wasn't just a mistake. It could be reckless disregard, maybe even fraud, depending on what she knew and when she knew it. Suddenly this case had teeth. Regina, sensing the ground shifting slightly, tried a new approach. She showed up at my office unannounced, all smiles, offering what she called a generous compromise. The HOA would pay me for the land, retroactively, at a price far below its actual value, if I dropped everything quietly. I told her I'd have my attorney review any offer in writing. Regina's smile flickered. You really want to drag this through court? Against an entire homeowners association? She asked, almost pitying. People like you rarely win against people like us, dear. Think about your daughter, she added, letting the implication hang there deliberately. Mentioning Emma was the moment I stopped seeing Regina as merely aggressive and started seeing her as someone willing to cross any line to protect her project. I didn't raise my voice. Court. And closed the door behind her. That evening I dug through my grandfather's old filing cabinet, the one I'd inherited along with the land, full of decades of receipts, letters, and yellowed legal correspondence. Somewhere in there, I hoped, was more than just a deed, some clue about why he'd bought this parcel at all. I found a manila folder labeled simply Ridge Parcel Reversion, tucked behind old tax statements. Inside was a photocopy of correspondence between my grandfather and his attorney from 1979, discussing a clause neither the HOA nor Regina appeared to know existed at all. The letter mentioned a reversionary interest tied to the original subdivision agreement, language stating that if the adjoining developer ever attempted
unauthorized development on the reserved parcel without formal transfer, ownership of any improvements would revert entirely to the parcel's title holder. I read it twice, heart pounding.
I brought the folder straight to Priya's office the next morning. She read the correspondence slowly, then read it again, tapping her pen against the desk. This is exactly the kind of clause developers used to bury in old subdivision agreements, she said. If it's still valid, this changes everything. She explained that reversion clauses like this were rare but not unheard of, especially from an era when small landowners negotiated protections against exactly this kind of encroachment. If the original subdivision agreement referenced it and it was never formally released, could still bind Ashford Meadows today. Priya sent a records request to the county archive for the full 1979 subdivision agreement, not just the plat map Regina had found. It would take time to locate the original filing, buried in decades-old microfiche most clerks hadn't touched in years. We needed patience we didn't quite have. Meanwhile, construction rolled forward at a brutal pace. 22 building pads now stood staked across the field, steel rebar cages rising for foundations, framing crews scheduled within weeks. Regina posted glossy renderings online, a retail plaza, a medical office park, a coffee shop with a rooftop patio. Homeowners in Ashford Meadows started talking about rental income projections, property value increases, the genius of Regina's vision. Nobody asked where the land title actually stood. Regina had turned my legal nightmare into her community's favorite dinner party topic, framed entirely as a triumph in progress, complete with printed handouts at the mailbox kiosk showing projected returns nobody had actually verified with any real accountant. I started attending HOA meetings, uninvited but not technically barred, sitting quietly in the back row while Regina presented updated timelines and glowing budget figures. She never once mentioned an ongoing lawsuit. She referred to me only obliquely as a legal matter being resolved by our counsel. One meeting, a homeowner named Priscilla Otero raised her hand and asked directly whether the land dispute could delay the project or cost the HOA money later. Regina laughed it off smoothly. "There's no real dispute," she said. "Just someone hoping for a payday. Our title is solid," she added, glancing briefly toward the back row where I sat. I sat there, folder in my lap containing a recorded deed, a 1979 reversion letter, and a county confirmation email, listening to a woman lie confidently to 60 of her own neighbors. It took everything in me not to stand up and read it all out loud right then. Priya advised against it. "Save it for court," she said. "If you show your hand now." Regina adjusts her strategy. Let her keep building on a foundation that isn't hers. The deeper she digs, the worse it gets for her when the truth surfaces. I trusted her judgment. Barely. Dale Voss, Regina's husband, started appearing at the site more often, watching foundation pours with visible tension in his shoulders. I later learned from Marcus that Dale had quietly warned Regina, weeks earlier, that the common reserve language was legally shaky without a formal title search. A warning she dismissed almost as quickly as she dismissed mine. Regina hadn't listened to her own husband. According to Marcus, she told Dale the project was too far along to stop now, and that she'd rather ask forgiveness than permission from a county government too slow to catch up with an ambitious community improvement plan. What Regina didn't know was that Dale had personally profited from steering title insurance business toward the project. A conflict of interest that would matter enormously later. At the time, all I knew was that even her own husband seemed nervous about what she'd started building. By early June, the county archive finally located the complete 1979 subdivision agreement. 92 pages of dense legal language most people would never read twice. Priya found the reversion clause on page 61, worded almost identically to the letter from my grandfather's old attorney, and she read it aloud to me twice over the phone just to make sure neither of us had misunderstood. The clause stated clearly, any development on the reserved parcel without a formal, recorded transfer of title would trigger automatic reversion of all improvements to the reserved parcel's lawful owner, upon that owner's written demand, effective from the date construction began. My hands shook reading it. Priya explained what that meant in plain terms. If the clause held up, everything the HOA built on my land, every foundation, every framed wall, eventually every finished building, would legally become mine the moment I formally invoked the clause, regardless of who paid for construction. We debated timing carefully. Invoke it too early, Priya said, and Regina might find a way to halt construction and argue the clause never applied. Let construction continue further, and the reversion would apply to more completed value. But the legal fight would also grow louder and messier. I thought of Emma, of the years my grandfather spent paying off this land one careful payment at a time, of Regina's casual threat about people like me never winning against people like her. I told Priya I wanted to wait, quietly, and let Regina keep building her own downfall. Felt strange, almost dangerous, sitting on a legal weapon that powerful without using it immediately. But Priya reminded me that patience wasn't weakness here, it was strategy. Every beam Regina raised on my land was a beam she was unknowingly building for someone else entirely. Construction accelerated through July. Framing crews worked 6 days a week. Regina held a ribbon-style, topping-out ceremony for the first 3 commercial buildings, posting photos of herself in a hard hat, champagne glass in hand, captioned "Vision becomes reality, Ashford Meadows Commercial Village." I watched that post from my kitchen table, Emma asleep upstairs, and felt something settle in my chest that wasn't anger anymore. It was closer to certainty. Regina had just publicly documented, with a timestamp, exactly how much value she was pouring into land she never legally owned. Marcus Webb reached out again, more shaken this time. He'd asked the HOA's actual attorney, hired late in the process, to confirm the title was clean. The attorney had quietly told the board there were unresolved questions that needed formal resolution before further vertical construction proceeded. Regina overruled her own attorney's caution, according to Marcus, telling the board that stopping now would cost more in penalties and reputation than any hypothetical legal risk later. She called the concern lawyer talk and pushed the vote through again. 5-2. Same as before. I asked Priya if that mattered legally. A board being warned directly by its own counsel and proceeding anyway. She said it mattered enormously. It moved Regina from a defense of honest mistake toward something much harder to explain away. Willful, informed disregard of a known legal risk. By August, 16 of the 22 buildings had exterior walls up. Retail signage vendors were already measuring storefronts. Regina announced pre-leasing to local businesses, collecting deposits from small shop owners eager for space in a growing area. None of them knew the ground beneath them wasn't secure, or that the lease they were signing listed a company most of them had never heard of. I felt a pang of guilt about those shop owners, people with no idea they were signing leases for buildings sitting on disputed land. Priya reminded me gently that their dispute, if any, would be with Regina and the HOA, not with me. I hadn't broken any promise to them. Still, it weighed on me at night, imagining families investing their savings into storefronts built on a foundation of someone else's arrogance. I started keeping a private list of the businesses signing leases, thinking that when this ended, I'd want to make things right with them somehow. Regina, meanwhile, grew bolder in public. At a town hall about local development, she name-dropped the project as proof of Ashford Meadows' leadership in smart growth, never once mentioning the injunction, the treasurer's objections, or the increasingly worried whispers from her own husband at home. A local news reporter, covering the town hall for a small business segment, asked Regina about rumors of a land dispute. Regina smiled for the camera and said, "There's no dispute. Just someone trying to profit off confusion. Our title work is airtight." The clip aired that weekend. Priya watched that clip 3 times, grinning in a way I hadn't seen from her yet. "She just told a television audience her title is airtight," Priya said. "That's not a defense anymore. That's a public statement we can use to show she never had any doubt, or lied knowing better." I started to understand something about Regina in those weeks. Her confidence wasn't rooted in facts. It was rooted in never having been stopped before. She'd built a reputation on speed and certainty, and she genuinely believed that momentum alone could outrun any inconvenient legal reality chasing her. What she hadn't planned for was a quiet paralegal who understood title law better than her own husband did, an old reversion clause buried in a manila folder, and a treasurer with a conscience keeping careful notes of every meeting where he'd raised the alarm and been ignored. For 2 weeks in late August, things went strangely still. Construction paused briefly for a supply delay, Framing lumber backed up at the regional yard. Regina used the lull to host a community barbecue celebrating the project's progress, inviting press, local officials, and every homeowner in Ashford Meadows. I wasn't invited, obviously, but Marcus sent me photos afterward. Regina stood at a podium in front of a banner reading, Ashford Meadows Commercial Village, Building Community, Building Value, flanked by Todd Bryant and 2 county commissioners who'd shown up for the free food and good press. One commissioner, unaware of the pending litigation, praised the HOA publicly for cutting through red tape to bring commercial development to the area faster than usual. Priya later noted that quote too, since it suggested even local officials had been kept in the dark about the ownership dispute. During that quiet stretch, I finally allowed myself to walk the property line again, past the framed buildings rising where my grandfather's pecan orchard used to stand. It hurt to see, but it also steadied something in me. This wasn't over. Strange way, only beginning, and I intended to see it through to the very end. Emma asked me one evening why we didn't visit the land anymore like we used to on weekends. I told her it was complicated right now, but that someday it would be ours again. Fully. The way her great-grandfather intended. She nodded like she believed me completely, which somehow helped. Priya used the pause to formally file our reversion claim in preparation, drafting the legal notice we'd eventually serve, timing it carefully around remaining construction milestones. She wanted the claim airtight, every citation correct, every exhibit labeled, before we handed Regina the paperwork that would upend her entire project. We also used the lull to depose Marcus Webb informally, capturing his account of board meetings, timelines, and warnings ignored, while memories were still fresh. His notes, kept diligently since spring, matched dates and details from the HOA's own official minutes almost perfectly, lending them enormous credibility once the time finally came to present them formally. Marcus admitted he'd stayed quiet publicly out of fear of being ostracized in a neighborhood where Regina's influence touched everything from the social committee to local school volunteer lists. He wasn't ready to testify openly yet, but he agreed his notes could be used, unattributed, for now. Meanwhile, Dale Voss grew visibly more anxious around the neighborhood, according to several sources Marcus mentioned. He'd started asking colleagues at the title company quiet questions about reversionary clauses in old subdivision agreements, apparently sensing something he hadn't wanted to admit to his wife directly. I learned later that Dale had personally arranged expedited title insurance for 3 of the pre-leasing retail tenants, bypassing a full search in the interest of speed. At Regina's insistence, that decision would come back around hard once the reversion claim became public and those policies were examined. The lumber delay ended in mid-September, and construction resumed at full force, crews working overtime to make up lost time before winter weather slowed things further. Regina announced an accelerated opening timeline, promising the first retail tenants could move in by early spring of the following year. Priya and I watched the accelerated timeline with something close to relief, strange as that sounds. Every additional dollar Regina poured into speeding up construction was a dollar she was unknowingly investing in a building she would soon no longer legally own, once our claim was formally served. She's about to build the case against herself faster than we ever could, Priya said one evening, reviewing updated cost estimates pulled from public HOA meeting minutes. Total project costs had climbed past $4 million. Every rushed decision Regina made only strengthened the value of what was coming. By October, all 22 building shells stood complete, painted in the muted earth tones Regina had chosen personally from a designer catalog. Interior build-out began immediately. Flooring, electrical, plumbing, storefront glass. From the road, it genuinely looked like a finished commercial village rising out of nowhere. The kind of tidy, prosperous-looking development that made passing drivers slow down and wonder how they'd missed it happening. Regina hosted weekly hard hat tours for prospective tenants, walking business owners through empty storefronts, describing foot traffic projections and parking capacity with practiced confidence. She'd become something of a local celebrity, quoted in a regional business magazine as the HOA president who built an empire. That magazine profile made Priya laugh out loud when she read it. An empire, she repeated. On land she never bought, never surveyed properly, and was warned about by her own attorney and her own husband. She's writing our closing argument for us, Priya said, tucking the printed article straight into our growing exhibit binder. I almost felt sorry for Regina. Almost. I didn't feel sorry for long. That same week, I learned from Marcus that Regina had pressured a dissenting board member, an elderly homeowner named Frank Delaney, into resigning after he asked one too many pointed questions about the title search at a public meeting, questions Regina had clearly hoped nobody would ever think to ask out loud. Frank had specifically asked to see the actual recorded title report, not just a summary, after hearing rumors from neighbors about a lawsuit. Regina told the board privately afterward that Frank was no longer aligned with the community's vision and suggested it was time for new blood on the board. Frank resigned quietly rather than fight, telling Marcus he was too old for neighborhood politics and didn't want the stress. Marcus felt a pang of guilt watching another dissenting voice disappear, but it also hardened his resolve to keep his own detailed notes, just in case. Regina replaced Frank with a homeowner named Cheryl Ott, a longtime friend from her book club, who voted in lockstep with every proposal Regina brought forward from that point on. The board's dissenting voices had shrunk from 2 to essentially none, and Regina moved even faster, with less internal pushback. Regina expanded the project's scope again, adding a rooftop event space to one building and upgrading finishes across the retail corridor, pushing costs even higher. She financed the additions through a special assessment on all Ashford Meadows homeowners, without a full community vote. Some homeowners grumbled about the surprise assessment on their HOA dues, but Regina framed it as a small, temporary sacrifice for long-term shared prosperity. Most paid it without much complaint, trusting the woman who'd spent years managing their landscaping disputes and pool schedules with total confidence. I started noticing something odd in the pre-leasing paperwork Marcus occasionally forwarded me, buried in HOA email threads he still had access to as treasurer. Several lease agreements listed the landlord not as Ashford Meadows HOA, but as a newly formed LLC, Meadow Commercial Holdings. Priya pulled the LLC's formation records from the Secretary of State's website. Meadow Commercial Holdings had been registered just 4 months earlier, with exactly 2 listed members, Regina Voss and Todd Bryant, the developer, not the HOA. Just the 2 of them, personally. That discovery changed everything about how we understood Regina's motives. This wasn't simply an overzealous HOA president making a reckless mistake for her community's benefit. She had quietly structured a private company to personally profit from lease income generated on land she didn't legally own at all. and had done so without telling a single homeowner funding the whole thing. Priya explained the implications carefully. If Meadow Commercial Holdings, not the HOA, would collect rental income from 22 buildings, then homeowners funding construction through special assessments were essentially financing a private business venture for Regina and Todd, disguised as a shared community investment project. I thought back to that HOA barbecue banner, building community, building value, suddenly read very differently. The community was building it. Regina and Todd seemed intended to keep most of the value for themselves, funneled quietly through an LLC most homeowners had never even heard mentioned. We debated whether to alert the HOA board directly about the LLC discovery before filing our reversion claim. Priya worried it might tip Regina off too early, giving her time to dissolve the LLC or restructure ownership before the claim's full impact could land as intended. Instead, we decided to let Marcus quietly document everything he could about Meadow Commercial Holdings' involvement in leasing, board communications, and financial arrangements, building a second, parallel case around potential breach of fiduciary duty that could run alongside our primary property reversion claim. Marcus, once hesitant, now moved with quiet determination, forwarding meeting invites, financial disclosures, and internal emails discussing lease terms that clearly favored the LLC over the general HOA membership. Every document strengthened a picture of calculated self-dealing dressed up as community leadership. By November, 14 of the 22 units had signed pre-leases, mostly small local businesses, a bakery, a pediatric dental office, a yoga studio, a boutique pet grooming salon. Real people, real savings, real hopes pinned on storefronts sitting on a legal foundation that was about to crumble beneath everyone involved, whether they realized it yet or not. I visited the site quietly one Sunday, parking on the public road, watching a young couple through their new storefront glass, unpacking bakery display cases with obvious excitement. I recognized the particular joy of people starting something they'd worked years to afford. It made everything heavier. Priya reminded me, gently but firmly, that none of this was my doing. Regina had built on disputed land without verifying title, ignored warnings from her own attorney and husband, replaced dissenting board members, and quietly funneled profits into a private LLC. Every consequence belonged to her choices. Still, I asked Priya if there was any way to protect those small tenants once the reversion claim succeeded. She said we could likely negotiate transition leases directly with them once I held clear title, since I'd have no interest in punishing shop owners caught in someone else's scheme. That reassurance helped me sleep a little easier. My fight had never been with a bakery owner or a dental hygienist chasing a dream storefront. My fight was with a woman who bulldozed my grandfather's orchard, threatened my daughter's future, and lied to a television camera without blinking. In late November, Priya finished the formal reversion notice, citing the 1979 subdivision agreement, the specific clause on page 61, my recorded deed, and a detailed timeline of construction beginning without any recorded transfer of title. It ran 11 pages, precise, devastating, and completely accurate. We debated the timing one final time. Construction was roughly 70% complete on interiors. Total project investment nearing $5 million, including the special assessments and construction loans. Regina had personally guaranteed alongside Todd Bryant through Meadow Commercial Holdings financing arrangement, a number that would only grow larger the longer we waited to act. Priya recommended waiting until after the holidays, letting Regina host one more triumphant public event, a planned winter preview, grand walkthrough, scheduled for early December, complete with press coverage, county officials, and prospective tenants touring nearly finished storefronts under twinkling lights. Let her have her moment, Priya said. Let every camera capture how finished, how valuable, how real this project looks. Every photo from that event becomes evidence of exactly what she built, and exactly what she's about to lose the second we serve this notice. I agreed completely. The winter preview arrived on a crisp December evening. String lights wrapped around lampposts, a local news van parked near the entrance, prospective tenants and homeowners strolling through nearly finished storefronts with paper cups of hot cider. Regina worked the crowd like a politician on election night. I stood across the road in my car, watching through the windshield, Priya beside me with a folder on her lap containing the formal reversion notice, ready for service the following morning. Regina laughed with a reporter, gesturing proudly toward the glowing storefronts behind her, utterly unaware. A county commissioner gave brief remarks praising visionary community leadership, specifically naming Regina, calling the project a model for public-private partnership in local development. He had no idea he was praising a private LLC quietly built on land obtained through willful disregard of a known legal defect. Todd Bryant stood near Regina throughout the evening, occasionally glancing at his phone, checking pre-lease numbers climbing toward completion. 17 of 22 units had signed by then. Dale Voss stood slightly apart from his wife, arms crossed, watching the crowd with an expression I couldn't quite read. After the event wrapped, local news ran a glowing segment that night calling Ashford Meadows Commercial Village a small-town success story, featuring interviews with excited shop owners and a closing shot of Regina cutting a ceremonial ribbon stretched across the plaza's central walkway, flashbulbs popping around her. The next morning, Priya personally delivered the formal reversion notice to the HOA's registered agent, to Regina directly at the clubhouse, and to Meadow Commercial Holdings' listed address, with copies simultaneously filed at the county recorder's office to establish an undisputed public timestamp on everything. The notice stated plainly, pursuant to the 1979 subdivision agreement's reversion clause, all improvements constructed on parcel 114B without a recorded transfer of title now legally reverted to Grace Calloway, effective immediately, with formal demand for recognition of title and cessation of all further construction activity, along with a request for a full accounting of any funds already collected from prospective tenants. Regina reportedly read the first paragraph standing at the clubhouse front desk. According to the office assistant who witnessed it and had to sit down, she called Dale immediately. She called Todd immediately after that. By noon, the HOA's actual attorney was fielding 3 panicked phone calls. By that afternoon, Regina called an emergency board meeting, closed to homeowners, citing an urgent legal matter requiring immediate discussion. Marcus attended, notebook in hand as always, watching Regina's composure crack in real time as she tried to explain the reversion notice without admitting how badly she'd miscalculated. The HOA's attorney, present for the emergency meeting, reportedly told the board bluntly that the reversion clause appeared valid on its face and that continuing construction now, with formal notice served, would only compound potential liability. He recommended an immediate, total halt to all site activity. Regina argued furiously against stopping, insisting the clause was ambiguous, that they should fight it in court while continuing to finish remaining units. Her own attorney reminded her, according to Marcus's notes, that proceeding now after formal notice could be used as evidence of willful, ongoing bad faith. The board voted, this time without Regina's usual control over the outcome, to immediately halt all construction pending legal review. Cheryl Lott, Regina's own ally, voted with the majority this time, visibly rattled by the attorney's blunt warning about personal liability exposure for board members. Word spread through Ashford Meadows within hours, this time not through Regina's carefully worded neighborhood app posts, but through frantic group chats, among homeowners demanding to know why construction had suddenly stopped the day after a glowing news segment aired, celebrating the project's near completion. Regina tried to control the narrative once more, posting a vague update calling it a temporary legal review of routine paperwork, but homeowners were no longer simply accepting her framing. Too many had seen the reversion notice mentioned by name in a leaked copy Marcus quietly shared with two trusted neighbors, and word traveled through the neighborhood faster than Regina could manage it. Priscilla Otero, the homeowner who'd raised concerns months earlier at a public meeting, forwarded the leaked notice to the entire homeowner email list, along with a pointed question. Had the board known about this reversion clause risk before spending millions in special assessments on the project? The response was immediate and furious. Homeowners who'd paid special assessments demanded answers. Several pre-lease tenants, including the bakery owner and the pediatric dentist, called the HOA office directly, asking whether their signed leases with Meadow Commercial Holdings were even valid anymore given the unfolding legal chaos. Local news, having run a glowing feature just days earlier, now scrambled to cover the reversal, sending a reporter to the clubhouse for comment. Regina refused an on-camera interview this time, a stark contrast to her confident appearance at the winter preview only 1 week before. The reporter instead interviewed Priscilla Otero on camera, standing outside the clubhouse, describing a homeowners association that had spent millions building on land its own president apparently never properly verified, while quietly steering lease income toward a private company she personally co-owned with the developer. That segment aired the following evening, and it spread across local social media within hours, homeowners sharing it with captions expressing shock, anger, and betrayal. Regina's carefully built public image, cultivated over years of confident leadership, began crumbling in real time, faster than her buildings had ever risen. One shared post at a time until the entire neighborhood app felt like a single, furious comment thread. Dale Voss stopped appearing at the site entirely after that broadcast. Marcus later learned Dale had quietly consulted his own employer's compliance department, worried about his role expediting title insurance for tenants without a proper search, a decision that could now expose him professionally as well. By the following week, 3 separate homeowners had contacted attorneys of their own, asking about potential claims against the HOA board for financial mismanagement and failure of fiduciary duty. Regina, once untouchable, suddenly found herself facing scrutiny from every direction at once, all at the same time. Rather than accept the situation, Regina escalated. She called me directly, a number Marcus admitted he'd once accidentally given her months earlier during a moment he regretted deeply. Her voice, usually smooth and controlled, now carried an edge of barely restrained desperation and fury. "You have no idea what you've done," she said. "Do you understand how many people you're hurting? Small business owners. A legal victory is going to destroy an entire community. And it'll be your name people remember for it, Not mine. I let her finish without interrupting. I told her calmly that I hadn't built anything on land that wasn't mine, hadn't ignored an attorney's warnings, hadn't formed a private LLC to profit off homeowners' special assessments, and hadn't threatened anyone's child to make a legal dispute disappear quietly. She hung up without responding. 2 days later, Regina tried something far more reckless. Marcus discovered, through a leaked internal email, that she'd instructed the HOA's maintenance crew to install a locked gate across the public access road leading to my property, claiming it was necessary for construction site security. That access road wasn't part of the disputed parcel at all. It was a separate, long-established right-of-way, deeded decades earlier, guaranteeing legal access to my land regardless of the ownership dispute next door. Blocking it wasn't a gray area. It was a direct, deliberate act of interference. I drove out that weekend to find a chain-link gate and padlock installed exactly where Marcus described, cutting off the only vehicle access to my grandfather's remaining acreage. I called Priya immediately, standing in the cold beside my car, staring at a lock that represented pure spite. Priya filed an emergency motion the following morning, this time not about title, but about unlawful obstruction of a recorded easement, attaching photos, the recorded right-of-way document, and Marcus's leaked email showing the instruction had come directly and explicitly from Regina herself. In writing, the judge, already aware of the ongoing reversion case, granted an immediate order requiring removal of the gate within 24 hours, along with a pointed warning that any further interference with access or property rights would result in sanctions against the HOA and Regina personally. Regina had the gate removed, but the damage to her position was already done. What had been, up to that point, largely a civil dispute over ambiguous old paperwork now looked unmistakably like a pattern of deliberate, escalating retaliation from someone unwilling to accept a legal setback gracefully, or at all. Priya used the gate incident to request expedited proceedings on the main reversion claim, arguing that Regina's continued hostile actions demonstrated urgent need for judicial resolution before further harm occurred to the property, the homeowners, or the small business tenants caught in the middle of everything. The court agreed, setting an accelerated hearing date for mid-January, less than 6 weeks away. For the first time since this entire ordeal began nearly a year earlier, I felt something shift meaningfully in our direction. A sense that the machinery of consequence was finally catching up to Regina. Regina, meanwhile, grew increasingly isolated within her own board. Cheryl Ott resigned quietly, citing personal reasons, though Marcus suspected she simply didn't want her name attached to Meadow Commercial Holdings' arrangement once regulators or attorneys started asking pointed questions about board members' financial involvement. With Cheryl gone, the board found itself with only 3 active members, barely enough for a quorum on any decision, and deeply divided on how to proceed. Some wanted to settle with me immediately to limit further financial damage. Regina, stubborn to the end, refused to consider surrender. "We didn't come this far to just hand it over," she reportedly told the remaining board members, according to Marcus's notes from that meeting. "I built this with an old piece of paper, take everything away because of a technicality nobody bothered to check." Marcus finally decided he could no longer stay quietly in the background. He requested a private meeting with Priya, bringing 8 months of detailed notes, forwarded emails, financial disclosures, and a clear, documented account of every warning Regina had received and ignored throughout the entire process. Priya reviewed everything for hours, occasionally letting out a low whistle at particularly damning entries. Marcus's notes confirmed the HOA's own attorney had warned about the title issue in writing twice, that Regina had personally overruled those warnings both times, and that Frank Delaney's resignation followed direct pressure. "This isn't just a property case anymore," Priya told me afterward. "This is a breach of fiduciary duty case, potentially a fraud case, and depending on how the LLC financing was structured, possibly something the county attorney's office would want to look at for misuse of homeowner assessment funds," she said, already reorganizing her exhibit binder to reflect the new scope. We discussed whether to bring Marcus's evidence into the upcoming reversion hearing directly, or hold it for a separate action homeowners might eventually pursue against Regina and the board. Priya decided some of it belonged in our hearing, since it directly established knowledge, timeline, and bad faith. Regina, unaware of exactly how much Marcus had compiled, continued preparing her own legal defense around the ambiguity argument, insisting the 1979 language was open to interpretation and that her belief in HOA ownership, however mistaken, had been made reasonably and in good faith at the time. That argument might have held some weight months earlier. But now it stood against a stack of evidence showing her own attorney's written warnings, her own husband's private doubts, a dissenting board member pressured into resignation, and a private LLC quietly funneling profits away from ordinary homeowners. As January approached, Priya and I spent long nights preparing exhibits. The original deed, the 1979 subdivision agreement, the reversion clause itself, the recorded easement violation, Marcus's meeting notes, the LLC formation documents, and screenshots of Regina's own public statements calling the title airtight on camera, each one labeled, cross-referenced, and organized into a binder thick enough to make Priya's paralegal joke it needed its own zip code. I thought often about my grandfather during those preparation nights, wondering what he'd think seeing his quiet 40 acres at the center of a legal battle covering fraud, fiduciary duty, and 22 half-built commercial buildings. I hoped, somehow, he'd be proud of how carefully we'd built our case. Regina's remaining allies on the board grew visibly nervous as the hearing date approached, some quietly reaching out to Priya's office asking about potential settlement terms independent of Regina's wishes, worried about personal liability exposure if the case proceeded to a full judgment against the association. Priya remained firm that any settlement discussion had to include full transparency about Meadow Commercial Holdings, full recognition of my title, and protection for the small business tenants who'd signed leases in good faith, unaware of the underlying ownership dispute swirling beneath their storefront windows. Regina, sensing her board wavering behind her, made one final, reckless move. She contacted Todd Bryant privately, according to a text message Marcus later obtained through a shared HOA document folder, discussing whether construction crews could quickly finish and occupy the remaining 5 unleased units before any ruling came down. The plan, apparently, was to argue that fully completed, tenant-occupied buildings would be harder for a court to order returned or demolished, hoping practical business disruption might pressure a judge toward a financial settlement instead of full property reversion, regardless of what the law technically required, and regardless of who actually held title on paper. Todd, increasingly nervous about his own liability given the LLC structure, refused to authorize additional spending without board approval, especially with construction officially halted under court order. Regina, without his cooperation, had no crew, no budget authority, and, increasingly, no allies left willing to follow her lead. Isolated and desperate, Regina made a final personal appeal, this time to me directly, showing up unannounced at my office building lobby, asking the receptionist to call up and say an old neighbor needed 5 minutes. I agreed to meet her downstairs, curious what she'd try next. She looked different than she had at the winter preview months earlier. Tired, thinner around the eyes, dressed more plainly than her usual polished HOA president appearance. "I'll admit fault publicly," she said quietly. "Just let the building stand. Let the tenants keep their leases. Please." I asked her why she hadn't offered that months ago. Before the gate. Before threatening my daughter's future. Before pressuring Frank Delaney into resignation. Before funneling homeowner assessments into a private LLC with her own name on it. She had no real answer. Just silence and lowered eyes. "I told myself I was building something good for the community," she finally said. Somewhere along the way I stopped checking whether that was actually true. It was the first honest sentence I'd heard from her in nearly a year, and it came far too late to matter legally. I told her I couldn't make promises about buildings or tenants outside of what the court would decide, but that I had no personal desire to punish shop owners who'd trusted her false confidence. What happened to her personally, though, was a separate matter entirely, out of my hands now. Regina left without another word, and I never spoke to her privately again after that afternoon. Whatever version of her existed before ambition curdled into arrogance, I never got to meet. I only knew the woman who'd bulldozed a pecan orchard and threatened a 7-year-old's future without hesitation. The board, learning of Regina's failed private appeal to me through Marcus, finally moved to suspend her authority pending the outcome of the hearing, appointing an interim HOA president to manage remaining community matters while the legal case proceeded toward its rapidly approaching January court date. Local news picked up that development too, running a follow-up segment on the HOA board suspending its own president amid mounting legal and financial controversy. Regina, once celebrated as a visionary leader, now appeared in headlines beside words like mismanagement, conflict of interest, and ongoing litigation. By the time the January hearing arrived, 22 half-finished commercial buildings stood silent under gray winter skies, construction fencing still wrapped around the site, 5 unleased storefronts dark and empty, 17 others waiting anxiously to learn whether their signed leases would even survive the coming ruling. The courthouse hearing room filled early that morning. Homeowners packed into gallery seats alongside several pre-lease tenants, local reporters, and county officials curious how a small property dispute had ballooned into a case covering fraud, fiduciary breach, and millions of dollars in disputed construction investment. The overflow crowd spilling into folding chairs set up along the back wall by a visibly surprised bailiff. Priya opened calmly, walking the judge through the timeline. My recorded 1979 deed, the reversion clause discovered in the original subdivision agreement, Regina's own admission on camera calling the title airtight, and the formal notice served the previous December triggering automatic reversion under the clause's plain language. Regina's attorney countered by arguing ambiguity in the decades-old Platt language, suggesting reasonable minds could interpret common reserve differently, and that the reversion clause, buried on page 61 of a lengthy agreement, shouldn't automatically override decades of assumed community use and good faith development investment. Priya rose calmly and introduced Marcus Webb as a witness, sworn in before a hushed room. Marcus described, methodically, every board meeting where the title issue had been raised, every warning from the HOA's own attorney, and every instance Regina had personally overruled caution in favor of speed. The judge asked Marcus directly whether the HOA attorney's written warnings had ever been shared with the full homeowner membership before special assessments were approved. Marcus answered plainly, no, they had not, and Regina had specifically instructed the board to characterize the matter as routine legal review instead. Priya then introduced the LLC formation documents for Meadow Commercial Holdings, showing Regina and Todd Bryant as its sole two members, alongside lease agreements listing the LLC, not the HOA, as landlord for all 22 units, despite homeowners funding construction through mandatory special assessments on their monthly dues. A visible murmur rippled through the gallery as homeowners in the audience realized, many for the first time in such stark detail, exactly how the financial structure had been arranged. Several exchanged furious glances. One woman near the back audibly whispered, "Our money went where?" Regina's attorney objected repeatedly, but the judge allowed the evidence, noting its clear relevance to establishing knowledge, intent, and good faith, all central questions in determining whether the reversion clause should apply straightforwardly or whether some equitable exception might be warranted under the circumstances presented. Priya then played the recorded local news clip of Regina calling the title airtight on camera months earlier, timestamped weeks after her own attorney had already warned the board in writing about unresolved title questions. The room fell completely silent as Regina's own recorded voice filled it. The judge asked Regina's attorney to explain that specific statement in light of the documented warnings. He struggled visibly, eventually conceding that his client's public confidence had, at minimum, outpaced the actual state of legal certainty available to her at the time she made those remarks. Then Priya introduced the gate incident, the blocked easement, the emergency motion, the court order for immediate removal, and the pointed judicial warning about further interference. It painted a pattern extending well beyond an honest mistake into deliberate retaliation against a legitimate, well-documented property claim. Finally, Priya read aloud the text message Marcus had obtained, showing Regina privately discussing rushing 5 remaining units to occupancy specifically to complicate any future court-ordered reversion, hoping practical business disruption might soften a ruling that the law, on its face, seemed to clearly require. Regina sat silently at the defense table throughout, jaw tight, staring at the folder in front of her rather than meeting anyone's eyes. Her attorney requested a brief recess to confer privately. The judge granted 15 minutes, and the gallery buzzed with hushed, urgent conversation the entire time. During the recess, according to a homeowner seated nearby who later described it to Marcus, Regina argued quietly but intensely with her own attorney, apparently pushing for a more aggressive defense strategy even now, unwilling to accept how thoroughly the evidence had assembled against her position. When proceedings resumed, Regina's attorney shifted strategy entirely, conceding the title issue likely favored me legally, but arguing for an equitable remedy, perhaps fair market compensation for the land rather than full reversion of 22 completed commercial structures representing millions in construction investment. Priya responded firmly that equitable remedies typically required clean hands, and that Regina's documented pattern of ignoring warnings, pressuring dissent into silence, structuring a private LLC for personal profit, and retaliating with an illegal gate closure disqualified any claim to equity or leniency from the court. The judge asked pointed questions about the LLC's financial structure, wanting to understand precisely how much personal profit Regina and Todd Bryant stood to gain from lease income before any reversion claim had been filed. Information Priya had already prepared in a detailed financial summary exhibit. That summary showed projected annual lease income across all 22 units exceeding $600,000, flowing entirely to Meadow Commercial Holdings, meaning homeowners' funding. Construction through special assessments would have received no direct financial return whatsoever from a project marketed to them as shared community investment from the very first presentation. The judge's expression shifted visibly reading that figure, and he asked Regina's attorney directly whether any homeowner vote had specifically approved routing lease revenue through a private LLC rather than the HOA itself. The attorney admitted, after a long pause, that no such vote had occurred. That admission landed heavily in the room. Priya had built her entire case on the reversion clause, but this financial revelation transformed the hearing from a technical property dispute into something the judge himself described moments later as a troubling pattern of self-dealing dressed in community language, a phrase reporters would repeat in nearly every headline that followed. Todd Bryant, present in the gallery but not called as a witness that day, slipped out during the recess that followed, phone already pressed to his ear. Marcus later heard he'd contacted his own separate attorney that same afternoon, apparently recognizing his exposure extended well beyond simple construction liability. The judge announced he would take a short recess before issuing a ruling, wanting time to review the full exhibit packet carefully given the case's unusual complexity, spanning property law, fiduciary duty questions, and the financial structure of a private LLC formed specifically around the disputed parcel. During that recess, homeowners in the gallery clustered in small, furious groups, comparing notes about special assessment amounts they'd personally paid, some doing quick mental math on exactly how much money had flowed toward Regina and Todd's private company instead of any shared community benefit. Priscilla Otero approached me during the break, something I hadn't expected. "I'm sorry," she said quietly. I believed her. "I hope you understand most of us had no idea what was really happening underneath all those renderings and ribbon cuttings." I nodded, genuinely moved. I told her I didn't blame ordinary homeowners for trusting their own HOA president, someone they'd voted for, someone who'd managed their community for years without apparent scandal. My anger had always been reserved for Regina specifically, not for neighbors caught believing a confident, well-rehearsed story. Marcus stood near the back of the hallway, looking simultaneously relieved and exhausted. 8 months of quiet documentation finally laid bare in open court. I walked over and thanked him directly, telling him his notes had likely changed the entire trajectory of what this hearing would decide. "I should have spoken up sooner," he said quietly. "I kept telling myself documenting things privately was enough, that I didn't need to be the one who caused a scene." I told him documentation was exactly what mattered most in the end, louder than any single dramatic outburst ever could. When the judge returned nearly 2 hours later, the room fell silent almost instantly. Homeowners, tenants, reporters, and board members all leaning forward slightly, waiting for a ruling that would determine ownership of 22 buildings, millions in investment, and the professional futures of at least 2 people. The judge began by acknowledging the case's unusual scope. noting that what started as a straightforward property boundary question had evolved into a far more troubling narrative involving ignored legal warnings, suppressed internal dissent, and a private financial arrangement inadequately disclosed to the very homeowners funding it. The judge ruled first on the reversion clause itself, finding it valid, properly recorded, and clearly triggered by construction beginning without any formal transfer of title from me or my grandfather's estate. All improvements on parcel 114B, effective from my formal notice, legally belong to me, in full, without qualification. A collective breath seemed to move through the gallery at that single sentence, though the judge continued speaking, clearly not finished. Regina sat frozen at the defense table, staring straight ahead, while her attorney scribbled notes beside her, already anticipating the questions still coming from the bench. The judge then addressed the equitable compensation argument directly, stating plainly that clean hands doctrine barred such relief here, citing Regina's documented disregard of her own attorney's written warnings, her husband's private concerns, and her decision to proceed despite clear internal objections raised repeatedly and ignored. He specifically referenced Frank Delaney's pressured resignation as evidence of suppressing legitimate dissent within the board's own decision-making process,
calling it deeply troubling behavior for someone entrusted with fiduciary responsibility over an entire community's shared financial resources and collective decision-making authority.
Then came the LLC ruling. The judge found that Meadow Commercial Holdings, structured entirely around lease income from buildings funded by homeowner special assessments without a specific authorizing vote, constituted a clear breach of fiduciary duty by Regina Voss in her role as HOA president. He ordered an immediate, independent financial audit of all HOA funds related to the project, referred the matter formally to the county attorney's office for review of potential fraud charges, and required Regina to personally account for any funds already distributed through the LLC to date, down to the last recorded transaction. Todd Bryant, though not present for that portion of the ruling, was named alongside Regina in the referral, given his direct co-ownership of the LLC and his role structuring lease agreements that routed tenant payments away from the HOA entirely, despite homeowners financing all underlying construction costs. The judge then turned to the practical question of the 22 buildings themselves, acknowledging the genuine hardship facing 17 small business tenants, who had signed leases in apparent good faith, unaware of the underlying ownership dispute simmering beneath their storefronts throughout the entire leasing process. He ordered a 90-day transition period during which existing tenant leases would remain valid under my ownership, giving both sides time to negotiate updated lease terms directly with me as the new, undisputed title holder, rather than forcing immediate closures that would harm innocent small business owners who had done nothing wrong at all. For the 5 unleased units, ownership transferred immediately and completely, free of any tenant complications, giving me full control to determine their future use without any competing claims or existing agreements complicating that decision going forward from the date of the ruling itself. The courtroom stayed remarkably quiet as the judge finished, homeowners absorbing the full weight of what they just witnessed. Their own HOA president, found to have breached her fiduciary duty, referred for potential fraud, while ownership of a multimillion-dollar commercial complex passed entirely to me. Regina finally spoke, standing briefly at her attorney's prompting, asking whether she could address the court directly. The judge allowed it, cautioning her that anything said could be considered in the county attorney's forthcoming review. She nodded, took a breath, and spoke anyway, voice noticeably unsteady. "I made mistakes," she said. "I let ambition get ahead of caution. I told myself I was building something for this community, and somewhere along the way I stopped questioning whether that was actually true anymore." It echoed almost exactly what she'd told me privately in my office lobby weeks earlier. The judge listened without visible reaction, then noted for the record that expressions of regret, however sincere, didn't change the legal findings already established through documented evidence presented throughout the hearing. Regina sat back down slowly, the fight finally, visibly gone from her posture entirely. Outside the courthouse afterward, reporters swarmed the front steps, cameras flashing as Regina walked quickly toward a waiting car without comment, her attorney shielding her from direct questions. Homeowners lingered nearby in small clusters, some still processing the sheer scale of what had just unfolded inside. Priscilla Otero found me on the courthouse steps, asking quietly what would happen to homeowners who'd paid special assessments toward a project that no longer belonged to the HOA at all. I told her honestly I didn't know yet, but that the audit ordered by the judge would likely determine that. Marcus stood a short distance away, notebook finally closed, looking like a man who'd set down a weight he'd carried far too long in silence. I hugged him briefly, surprising us both, thanking him again for the courage it took to finally bring everything into the open air. That evening, local news ran extensive coverage of the ruling, featuring interviews with several homeowners expressing shock and anger, footage of the silent, half-finished commercial buildings under gray winter sky, and a brief statement from the county attorney's office confirming a formal fraud investigation was now underway, one that would occupy headlines for months to come. I drove home that night past the property, the 22 buildings standing quietly in the dark, no longer strangers' construction on my grandfather's land, but genuinely, legally mine, complete with all the complicated responsibility and opportunity that reversal now carried squarely onto my own shoulders going forward. Emma asked me the next morning if we'd get to visit the land again soon. I told her yes, very soon, and that someday she'd understand the whole complicated story behind it. But for now what mattered most was that it belonged to our family again, exactly as her great-grandfather intended. In the weeks following the ruling, the court-ordered financial audit uncovered even more than anyone initially expected. Meadow Commercial Holdings had received nearly $200,000 in tenant deposits and early rent payments, none of which had ever been disclosed to the general HOA membership at all. Investigators also found that Dale Voss's title company had processed expedited title insurance for 3 tenants without conducting full searches, at Regina's direct request, creating additional civil exposure for the company and prompting Dale's quiet resignation from his position before formal disciplinary proceedings could even begin. Todd Bryant, facing mounting pressure from his own attorney and the ongoing fraud referral, agreed to cooperate fully with investigators in exchange for reduced personal liability, providing detailed records of the LLC's formation and financial decisions that further implicated Regina as the arrangement's primary architect throughout. The county attorney's office formally charged Regina with fraud and breach of fiduciary duty roughly 6 weeks after the ruling, citing the documented pattern of ignored warnings, suppressed dissent, and undisclosed private financial benefit at the direct expense of homeowners who had trusted her leadership completely, year after year, without ever once thinking to ask for real proof. Regina's case drew significant local media attention, her name appearing in headlines she certainly never imagined when she first found that old plat map language in a dusty HOA records box, convinced she'd discovered a shortcut to community prosperity rather than the beginning of her own downfall. Meanwhile, I began the complicated process of formally taking possession of 22 commercial buildings I'd never asked for and never wanted in quite this way, working with Priya to establish proper management structures, review existing tenant leases fairly, and figure out what genuine stewardship of the property should actually look like. Day by day, I met personally with each of the 17 existing tenants. Starting with the young couple running the bakery I'd watched unpacking display cases months earlier. I explained the situation honestly, offered updated leases at fair market terms, and promised transparency they clearly hadn't received throughout the entire previous ownership arrangement. Most tenants expressed relief more than anger, grateful simply to have clarity and a straightforward path forward after months of confusing rumors and uncertain news coverage. The bakery owner, a woman named Teresa, told me she'd nearly walked away entirely before hearing directly from me about the new arrangement. I decided against pursuing sale of the entire complex, despite several developers expressing immediate interest once news of clear title spread through local business circles. Something about my grandfather's orchard, however transformed now, made me want to steward what remained rather than simply cash out and walk away. Marcus, having resigned from the HOA board shortly after the ruling, citing a need for distance from the entire ordeal, agreed to help me manage tenant relations and property oversight moving forward, a role that suited his careful, detail-oriented nature far better than HOA board politics ever had. The 5 previously unleased units, free of any competing claims, became something entirely new, a small community resource center, a job training partnership space, and a modest scholarship-funded storefront offering free legal aid consultations, something Priya helped establish in honor of everything this ordeal had taught us both. Regina's criminal trial began nearly a year after the property ruling, drawing renewed local media attention as prosecutors laid out the same documented pattern. Established in civil court, ignored warnings, suppressed dissent, an undisclosed private LLC, and diverted tenant payments totaling nearly $200,000. Marcus testified again, calmly and methodically, walking jurors through the same timeline he'd once kept quietly in a personal notebook out of fear rather than confidence. This time, he spoke without hesitation, no longer worried about neighborhood politics or Regina's fading influence over anyone's social standing. 242. Dale Voss, granted limited immunity in exchange for full cooperation, testified about the expedited title insurance decisions made at Regina's direct request, describing his own growing unease throughout the process and his private, unheeded warnings about the reversion clause's potential legal significance months before anyone else noticed. Todd Bryant similarly testified under his cooperation agreement, confirming Regina had structured Meadow Commercial Holdings specifically to capture lease income personally, describing conversations where she dismissed his own occasional concerns by insisting, "The board trusts me completely, and that's all that actually matters here." Priscilla Otero testified as well, describing the special assessments she and other homeowners had paid without ever being told a private LLC, not the HOA itself, would collect the resulting lease income, calling it a betrayal of the exact trust every homeowner extends to their own elected leadership, a line that visibly moved several jurors as she spoke it. I testified last, walking the jury through the entire timeline from my perspective, the survey stakes appearing without warning, Regina's dismissive confidence at our first meeting, the bulldozed pecan orchard, the blocked easement, and her private admission of regret weeks before the hearing that ultimately changed everything. The prosecutor asked me directly whether I'd taken any satisfaction in watching Regina's empire collapse. I answered honestly, mostly, I felt relief and a quiet sadness that something so avoidable had cost so many people so much, simply because one woman refused to accept a warning seriously. The jury deliberated for just under 6 hours before returning a verdict, guilty on both fraud and breach of fiduciary duty charges. Regina showed little visible reaction, standing quietly as the verdict was read, her once confident posture replaced by something smaller, quieter, and considerably more human. The judge, at sentencing several weeks later, cited the documented pattern of suppressed dissent and personal financial gain at community expense as particularly aggravating factors, sentencing Regina to restitution covering the full diverted tenant payments, along with a period of supervised probation and a permanent HOA leadership ban. Todd Bryant, having cooperated fully, received a significantly reduced sentence involving substantial financial restitution but no additional jail time, while Dale Voss faced separate professional licensing consequences through his former employer's industry regulator, effectively ending his career in the title insurance business entirely going forward. Regina's restitution obligation required repayment of the roughly $200,000 diverted through Meadow Commercial Holdings directly to the tenants and
homeowners affected, a process PRIA helped coordinate to ensure funds actually reached the people harmed rather than disappearing into further legal complications.
Teresa, the bakery owner, used part of her restitution payment to finally renovate her storefront's kitchen equipment, something she'd been putting off for months during the ownership uncertainty. She sent me a small basket of pastries afterward with a note simply reading, "Thank you for choosing us over profit." Ashford Meadows elected an entirely new HOA board within months of Regina's conviction, implementing stricter financial transparency rules requiring full homeowner votes on any project exceeding a modest spending threshold, along with mandatory independent title verification for any future development involving adjacent or disputed parcels. Marcus, somewhat reluctantly, agreed to serve as an advisor to the new board during its transition, sharing hard-won lessons about the importance of speaking up early rather than quietly documenting concerns from the sidelines while waiting for someone else to eventually take the necessary risk instead. I occasionally saw Regina's name mentioned in local news follow-ups over the following year, mostly regarding her ongoing restitution payments and the permanent HOA leadership ban that effectively ended the community influence she'd spent years carefully building before ambition finally outran her better judgment entirely. Emma, older now and old enough to understand a simplified version of the whole story, occasionally asked about the buildings, proud in her own small way that her great-grandfather's quiet 40 acres had somehow become something the whole town still talked about, for better and for worse. I kept my grandfather's original filing cabinet in my new property management office. The manila folder labeled Ridge Parcel, reversion now framed on the wall above it, a quiet reminder that patience, documentation, and a single overlooked clause had ultimately outlasted arrogance, intimidation, and outright fraud. 2 years after the ruling, all 22 buildings stood fully leased, occupied by a mix of small local businesses and the Community Resource Center PRIA and I had established together. What Regina had built for personal profit had become, gradually, something genuinely useful for the whole town. I planted 3 new pecan trees along the property's edge that spring, saplings small and unimpressive now, but someday, I hoped, They'd stand as tall and steady as the ones Regina's bulldozers had cleared away without a second thought, back when she believed nothing could ever stop her. Priscilla Otero and Teresa became genuine friends over those 2 years, occasionally joining Emma and me for coffee at the bakery on quiet Saturday mornings. An unlikely friendship born entirely out of a dispute none of us had ever wanted or expected in the first place. Sometimes, walking the property line where survey stakes once marched across my grandfather's orchard like an invasion, I think about how close Regina came to simply taking everything, and how one forgotten clause, one quiet paralegal, and one nervous treasurer's careful notes changed absolutely everything in the end. The county's Homeowner Association Oversight Board later cited the Ashford Meadows case as a model example in new statewide training materials, warning HOA leaders everywhere about the dangers of proceeding on undisclosed title assumptions without proper verification, regardless of how confident or well-intentioned a project's leadership might feel. Local real estate attorneys began referencing the case informally as a cautionary tale for developers and HOA boards alike. A reminder that decades-old plat language deserves careful legal review, not convenient interpretation, before millions of dollars and dozens of small business dreams get built on top of it. Dale Voss eventually left the title insurance industry entirely, taking a quieter administrative job in a different field altogether, rarely mentioned in town beyond occasional passing references to Regina Voss's husband, whenever the case resurfaced in conversation among longtime Ashford Meadows residents. Todd Bryant returned to smaller residential construction projects after his restitution obligations concluded, reportedly far more cautious about verifying property titles before breaking ground on any future development, a lesson he apparently carried forward long after the Ashford Meadows controversy finally faded from daily conversation. Regina moved out of Ashford Meadows roughly 18 months after her conviction, selling her house quietly without the fanfare that once accompanied nearly everything she did in that community, her name gradually fading from neighborhood conversation the way most difficult chapters eventually do with enough time. I still own the land my grandfather left me, along with 22 buildings I never asked to inherit, run honestly, transparently, and for the benefit of the tenants and neighbors who actually depend on them, rather than for the private profit of anyone hiding behind community language. Emma will inherit all of it someday, along with the manila folder, the framed reversion clause, and hopefully the lesson underneath all of it, that quiet patience, careful documentation, and simple honesty can outlast even the most confident, most controlling, most determined arrogance in the end. The pecan trees are still small, but they're growing steadily, exactly the way my grandfather always said things worth having usually do.